Hello and welcome to Unacademy. Welcome to Polity Project 2.0. In this series, in lecture number 1, we discussed fundamental duties. Lecture number 2, collegium system versus NJAC. Lecture number 3, we discussed all the important doctrines in one video. Lecture number 4, yesterday, we discussed the Representation of the People Act 1951. And today in lecture number 5, we will discuss all that you need to know regarding constitutional amendments, how Indian Constitution can be amended. But first up, let's take a look at this PYQ. This question was asked in Prelims 2024. As per Article 368 of the Constitution of India, the Parliament may amend any provision of the Constitution by way of, can Parliament add something, vary something, modify something, repeal something? Yes. Adding something to the Constitution, varying the existing provisions in the Constitution, repealing something from the Constitution, that's the power available with the Parliament under Article 368. So A, D, 1, 2, 3 is the right answer. But what is the need to amend the Constitution? Let's look at the views of Pandit Nehru, the first Prime Minister of India. He said, Constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. After all, what is a Constitution? Constitution is the document of people's faith and aspirations. The aspirations of the people keep on changing. So what were the aspirations of the people of this country in 1950 when the Constitution was adopted may not be the same as the aspirations of the people in 2026 or in 2056. So this Constitution, which was enacted in 1950, needs to undergo those changes as are demanded by the people. That is why Pandit Nehru said, Constitution cannot remain a rigid document. It has to change. It has to be a living document. It has to adapt to the changing realities of our time. And any popular demand of the electorate, of the people, should be capable of realization. Dr. Ambedkar, he said, the Constitution that I have drafted, it is not necessary that everybody would praise this Constitution. Everybody would be happy with this Constitution. It may be possible that you are dissatisfied with this Constitution. And if you are dissatisfied with the Constitution, get 2/3 majority in the Parliament and change it. Which means, after all, there would be periodic elections in this country. People will elect their representatives on the basis of universal adult franchise. And your representatives would be there in the Parliament. Get 2/3 of these representatives, change the Constitution, amend the Constitution, and Constitution will stand changed and amended. But if you cannot get 2/3 majority in the Parliament to change the Constitution, then I can assume that only you are dissatisfied with the Constitution. Your dissatisfaction is not shared by the wider public, by the general public, by the majority. And democracy is about majority in numbers. Long story short, making any change to the Constitution is constitutional amendment. And Constitution has given this power under Article 368 to the Union Legislature, which is the Parliament, that you can use Article 368 and you can make amendments to the Indian Constitution. And what is the need? What is the purpose? Because Constitution, after all, is a document of people's faith and aspirations keep on changing. You need to change the Constitution so that this Constitution reflects the aspirations of the contemporary society of India. Dr. Ambedkar said, you're not satisfied with the Constitution? Get 2/3 majority in the Parliament and change the Constitution. But now the question is, how? And before we start that, let me tell you something very important. Should you wish to prepare with us, live classes, study material, test series, mentorship, current affairs, all that you need to crack this examination, we promise we will provide you All you have to do is subscribe to our UPSC subscription, go through our website, check various plans, whether you need Plus, Iconic, Iconic Pro, or Platinum. If you want Plus, then Plus subscription is now available at 17,999. Use this code while you subscribe to our courses, and automatically the lowest price fee will be displayed for you. And if you're confused as to how many months should I subscribe to this plan, my advice would be, if you're attempting 2027, 18-month subscription is more than sufficient for you. Now let's continue and let's look at Shankari Prasad Dev v. Union of India 1951. What did Dr. Ambedkar say? If you're not satisfied with the constitution, get 2/3 majority in the parliament and change the constitution. Which means, is there a limit that parliament can change these provisions, but other provisions parliament cannot change? Is there any limit on the amending powers of the parliament? The short answer is no. If we plainly read the plain text of the constitution. Immediately after the commencement of the constitution, various changes were made to the constitution. Fundamental rights were modified. Article 15 was modified. Land reforms were implemented. Zamindari system was abolished. 9th schedule was added to the constitution. And any law which is placed in 9th schedule, there is no judicial review at that point in time. Matter went to the court. Supreme Court said that there is no limit on the amendatory powers of the parliament. If parliament uses Article 368, parliament can make any change to the constitution. Can it amend fundamental rights? Yes. Can it modify fundamental rights? Yes. So any change that you can make to the constitution can be done only through Article 368. But there is no limit to the amendatory powers of the parliament. But this position of the Supreme Court changed a decade and a half later in Golaknath v. State of Punjab, 1967. Supreme Court said, Article 368 only talks about procedure to amend the constitution. It does not give the parliament the power to amend the constitution. Fundamental rights under Part 3 of the constitution are beyond the amendatory powers of the parliament. Parliament cannot dare touch fundamental rights. Long story short, in Shankari Prasad, the Supreme Court is saying parliament can amend the constitution, but not through ordinary laws, not through ordinances, not through rules, but only through a constitutional amendment act, that too under Article 368 of the Constitution. But this position has been completely reversed in the Golaknath case, where an 11-judge bench of the Supreme Court said, Part 3 and the fundamental rights which are provided under Part 3, they are beyond the amendatory powers of the parliament. Parliament cannot, even by using Article 368, change fundamental rights, modify fundamental rights, vary, repeal fundamental rights. No. If you want to make changes to fundamental rights, Golaknath case, Supreme Court suggested, maybe set up a constituent assembly. This constituent assembly may be set up, and then this constituent assembly may use the procedure which is mentioned under Article 368 to make any changes to fundamental rights. But this parliament, it only has an ordinary law-making power. It does not have a constituent power, which means it can make ordinary laws, but it cannot amend the constitution's fundamental rights. Finally, this position was settled in the landmark case known as Kesavananda Bharati v. State of Kerala, 1973. And it is in this case that Supreme Court propounded a doctrine called Basic Structure. Now, what is the current situation? Yes, Parliament can use Article 368 to make changes to the Constitution, including fundamental rights, Modify fundamental rights, yes. Repeal some of the fundamental rights, yes. As long as you are not touching, violating the basic structure of the Constitution. And what is this basic structure? A very important constitutional luminary, Nani Palkhiwala, He was the lawyer, one of the principal lawyers in this case. He thundered before the 13-judge bench of the Supreme Court and asked few pointed questions. He asked the Supreme Court, don't you think, my lord, there is something called implied restriction? The court asked, what is this implied restriction? Listen to me carefully. Nani Palkhiwala said, there is no limit mentioned in the Constitution explicitly which can impose a limitation on the amendatory powers of the Parliament, because it's not mentioned in the Constitution that Parliament can amend these provisions but cannot amend these provisions. There is no limitation. But there is an implied limitation, implied restriction. Even if explicitly it is not mentioned, but there are some restrictions on the amendatory powers of the Parliament. And Nani Palkhiwala says, how? Can my lord, and this is the question that he's asking the Supreme Court, if there is no limit to the amendatory powers of the Parliament, can tomorrow Parliament amend the Constitution and convert the democratic Constitution into a monarchy? Because there is no limit on the powers available with the Parliament. Parliament can do anything. Can this Parliament then convert our democratic polity into a monarchy? Or leave that? Can this democratic country be gifted back to the British Empire? Is there a power, such a power available with the Parliament? Can Parliament tomorrow use Article 368 and delete Article 21, which is right to life and personal liberty? Can Parliament tomorrow enact a law and say from now onwards elections will not be conducted? This is the last election. If you have the power to amend the Constitution using Article 368, can Parliament amend and repeal Part 1, Part 2, Part 3, Part 4 to such an extent that nothing remains in the Constitution? Because if you have no limit on the amendatory powers of the Parliament, can you use Article 368 to even abrogate the Constitution to such a level that nothing remains? Should something remain in the Constitution, which is something that you can't change, something you can't remove, that's something which must remain at all times is basic structure. Although Supreme Court did not agree with this implied restriction argument, Supreme Court instead propounded a doctrine called basic structure. There are some basic fundamental features of the Constitution which cannot be changed, which cannot be altered, even by a constitutional amendment. And Supreme Court over a period of time has enlarged the list of this basic structure. Supreme Court has said rule of law is part of the basic structure. Objectives mentioned in the preamble are part of the basic structure. Parliamentary form of government is part of the basic structure, which means with the same constitution, can we convert our constitution from parliamentary to presidential form of polity? No, because parliamentary form of government is part of the basic structure. Federalism is part of the basic structure. Free and fair elections, independence of judiciary, judicial review is part of the basic structure. So all these are part of the basic structure, which means, long story short, what is amendment to the Constitution? Making any change to the Constitution is an amendment. Whether you are adding something, repealing something, or modifying something, that's amendment. Who has this power? Parliament, Union Legislature under Article 368. Is this power unrestricted? No. You can, as a Parliament, use Article 368 to make any changes to the Constitution, but not these changes, without affecting these. Why? Because all these are part of the basic structure. Can tomorrow Supreme Court add another basic structure? Yes. Supreme Court has the power to keep on adding to this list, and they have the power to decide what constitutes basic structure. But now the point is, if Parliament has the power to amend the Constitution without violating basic structure, without disturbing basic structure, what is the procedure? For that, we need a bill. Now, what is a bill? Bill is a proposal. Let's say the proposal is to add a fundamental right, remove a fundamental right, modify a fundamental right without disturbing the basic structure, add an article, remove an article, add a schedule. That is a proposal. So the proposal is to add something to the Constitution, to repeal something from the Constitution, to modify something in the Constitution. That's a bill. This bill has to be introduced. Where? In the Parliament. But where? First in Lok Sabha and then in Rajya Sabha, or first in Rajya Sabha and then in Lok Sabha. This bill can be introduced in either of the two houses. Which means, for example, a bill, money bill, financial bill can be introduced only in the Lok Sabha. But that is not a criteria for a constitutional amendment bill. This constitutional amendment bill can be introduced in either of the two houses. But who can introduce it? Only a minister or a private member? But sir, what's the difference between a minister and a private member? Minister is a minister, and somebody who is not a minister is a private member. For example, even if you belong to the BJP, even if you are a member of the Lok Sabha or Rajya Sabha from the BJP, and the BJP is the party in power, but you are not a minister, maybe somebody like Manoj Tiwari, you are a legislator, but you are not a minister, you are a private member. So don't assume that private members are those members of the parliament who belong to the opposition. No. Even if you belong to the party in power, but you are not a minister, you are a private member. So this bill can be introduced by either a minister or by a private member. And this bill does not require prior permission of the president. These steps are very important. Once you have that clarity, you will not skip any question in the examination. You will not make any mistakes on this topic. There are some bills for which prior permission of the president is necessary. For example, can a money bill be introduced without the prior approval of the president? No. Ditto for financial bill. Ditto for a bill under Article 3 as well, calling for the reorganization of the states. But listen to me carefully. What if, I'm just giving a hypothetical situation. What if a money bill is introduced in the Lok Sabha by the minister without prior permission of the president? Is it violation of the Constitution? You will not be able to answer with this information that I provided, because you need some more information. And what is that more information? Listen to me carefully. If a money bill has been introduced in the Lok Sabha without prior permission of the president, but Lok Sabha passed it, then Rajya Sabha also passed this, then this bill was sent to president. President also gave assent to this money bill. Can this bill be challenged in the court on the grounds that prior permission of the president was not taken? No, because this is just a formality. Because in the first instance, if prior permission of the president was not taken, but later on, when the bill was passed by both houses of the parliament, sent to the president for assent, president did not hesitate and signed this bill, gave assent to this bill, which means president is in agreement with this bill. Now you can't challenge this bill, this law, on the ground that prior permission of the president was not taken. But long story short, there are some bills for which prior permission of the president is required, but not for a constitutional amendment bill, which means a constitutional amendment bill can be introduced in either of the two houses of the Indian Parliament without any requirement of the prior permission of the president, can be introduced by either a minister or by a private member, and this bill requires special majority to pass in both the houses, which means in Lok Sabha, special majority, in the Rajya Sabha, special majority. What type of special majority? Special majority flavor 2. Sir, what is this flavor 2? Flavor 2 means 2/3 of the members present and voting. I'll mention it here. 2/3 of the members present and voting plus majority of the total membership of the House. And what is this majority of the total membership of the House? This is what we call absolute majority. So this bill, constitutional amendment bill, has to be passed by both houses of the parliament by special majority. What if one house passes this bill and the other house does not? Which means there is a deadlock. And you must have discussed, you must have read, you may have read about deadlock. And to resolve a deadlock, there is something called joint sitting of both the houses of the parliament. Which means on a particular bill, if there is a deadlock between the two houses, one house agrees, the other house does not, then to resolve this deadlock, there is a joint sitting. But there cannot be a joint sitting for a constitutional amendment bill. Which means this constitutional amendment bill shall have to be passed by both houses of the Indian Parliament by special majority separately. There is no provision of the joint sitting. But if this bill wants to amend some of the federal features of the constitutions, federal provisions of the constitution, then this bill needs to be ratified by at least half of the Indian states as well by simple majority. So what are you trying to say? If there's a constitutional amendment bill, but this constitutional amendment bill tries to amend some of the federal provisions of the constitution. So which are these federal provisions? I'll tell you slightly later. But if this bill tries to amend some of the federal features of the constitution, this bill needs to be passed by both houses of the Indian Parliament. But before you send it to the president, you have to send it to all the state legislatures in India. Which state legislatures? State legislative assemblies. Does this include the legislative assemblies of union territories as well? Yes. Only when not less than half of these state legislatures accept this constitutional amendment. Because you are trying to amend the constitution, maybe violate the powers of the states. So you need the state's ratification for that. And if not less than half of the states ratify, agree with this constitutional amendment, then you can send this bill to the president. President may sign this bill. But how do we know whether the state legislative assemblies have accepted this constitutional amendment or not? By what majority do they have to decide this? The majority required is simple majority. So simple majority ratification by the states, but special majority required in the parliament. And once this bill is passed, it is sent to the president. What are the options available with the president? There is only one option. Or may I dare say, there are two options. Option number one, you shall give his assent. This term shall makes it legally binding on the president to give assent to this bill. That means the president cannot return this bill, cannot say, I'm not going to sign this bill, cannot sit on this bill. No, the president has only one option, which is to give signature to this. Although this was not originally part of the constitution. This was added to the constitution by the 24th Constitutional Amendment Act 1971. Prior to that, on a constitutional amendment bill, the president could have used absolute veto or suspensive veto, but not after this Constitutional Amendment Act in 1971. But then, sir, you said president has two options. One is the president shall sign. What is the other option? Maybe the president resigns before signing. If you don't do this, you are liable to be impeached on the grounds of violation of the Constitution. Because the President of India can be removed from his office, impeached from his office on the grounds of violation of the Constitution. But is this term violation of the Constitution defined in the Constitution anywhere? No, it's not defined. So it's about interpretation. And if the Constitution tells you that the president shall give assent to a constitutional amendment bill, which means you have no other option but to sign. And if you don't sign, you're basically violating the Constitution. And violation of the Constitution is a fit ground of impeachment of the President of India. And once the president signs, this bill becomes an act. But now listen to me carefully. There is a misconception amongst the students because they read M. Lakshmikant and they think that Constitution can be amended by simple majority, by special majority with ratification by the states. No. Constitution can be amended only by special majority, full stop. Can Constitution be amended by simple majority? No. But sir, why does then Lakshmikant write that there are some provisions of the Constitution which can be amended by simple majority? Technically, it is incorrect. Then what is the correct position? Constitution cannot be amended by simple majority. But yes, the changes that you are making to the Constitution by simple majority, Constitution itself says, don't deem them as constitutional amendment. That means although you are making changes to the Constitution, but these changes shall not be deemed as an amendment to the Constitution. When these are not amendment to the Constitution, which means you don't need Article 368. Otherwise, Constitution can be amended only under Article 368. But as some sort of a flexibility, some flexibility is provided by the Constituent Assembly to the Parliament, that you can make changes to the Constitution. For that, you don't have to use Article 368 route, which means you don't need special majority to make these changes. You can make these changes by simple majority, but we will not call it amendment. For example, when a new state is created, you have to mention the name of this new state in Schedule 1. You have to mention the number of Rajya Sabha MPs belonging to the state in Schedule 4. When you make changes to Schedule 1 and Schedule 4, it is not deemed as an amendment, which means you can do this by simple majority. There are some states which have legislative council. There are some states which do not have a legislative council. Andhra Pradesh, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. These are the only 6 states in India which have a legislative council. Who can establish a legislative council? Parliament. Who can abolish a legislative council? Parliament. But if Parliament wants to abolish legislative council for Karnataka and wants to establish legislative council for, let's say, Odisha, for that Parliament does not have to use Article 368. Flexibility is provided to the Parliament that in these matters, you can make a law by simple majority. Article 124 says there shall be a Supreme Court of India consisting of the Chief Justice of India and not more than 7 judges. This was the original Constitution of 1950. Can we increase the number of judges? Yes, we can. Have we increased the number of judges? Yes, we have. Right now, we have a Chief Justice of India and not more than 33 other judges. These 33 other judges are also known as brother judges or puisne judges. Can we increase this number from 33 to 50, to 53, to 93, to 103? Yes. Who will change it? Who will increase it? Parliament. How? By passing a law by simple majority. Would it be deemed as a constitutional amendment? No. Why? Because Constitution says it is not a constitutional amendment. Initially, Constitution said Hindi will be the official language of the Union. But for 15 years, which means till 1965, we will use English as well. Can this English be used after 1965 as well? Yes. Who will decide that? Parliament. How? By enacting a law. Which law? Constitutional amendment? No. By simple majority. Which means even if Constitution says, just look at it this way, Constitution says that the official language of the Union is Hindi in Devanagari script and we will use English only for 15 years. So that's mentioned in the Constitution. Can Parliament pass a law, an ordinary law, by simple majority and change it? Because amendment can be done only by special majority. No, Parliament cannot do that. But Constitution itself says, Parliament, you can make this change. And you can say that we will continue using English even beyond 15 years, even beyond 1965. For that, you don't have to amend the Constitution. I am telling you, this is not a constitutional amendment. You can make changes through simple majority. But majority of the provisions of the Constitution can be changed by special majority. And that is how fundamental rights can be changed, subject to basic structure. DPSPs can be changed. And we have seen additions in DPSPs. So when the right to property was deleted as a fundamental right, it was a constitutional amendment by special majority, 44th Amendment. When anti-defection law was enacted and inserted into the Constitution by the 52nd Constitutional Amendment Act 1985, special majority was required, special majority was obtained. So some changes can be made to the Constitution, and for the sake of flexibility, those changes can be made by simple majority by the Parliament, but we will not call them constitutional amendment. Constitution can be amended only by special majority, and that too through this route. But I told you, if you want to make any changes to some of the federal features of the Constitution, which are the federal features? The election and manner of the election of the President of India. President of India is elected by the people of this country, but not directly, indirectly, through Electoral College. Electoral College includes the state legislative assemblies. What if tomorrow Parliament enacts a law and says from now onwards Electoral College will include only the elected members of Rajya Sabha and Lok Sabha? States will not be included in this Electoral College. Can you do that? You need to get the ratification by 1/2 of the states. Otherwise, you can't. When NJAC was introduced, National Judicial Appointments Commission, that was done through 99th Constitutional Amendment because it dealt with Supreme Court and High Courts. And when you make changes regarding the appointments to the Supreme Court and High Court, you need ratification by 1/2 of the states as well. When GST was introduced in India in 2017, it was a constitutional amendment ratified by 1/2 of the states. Why? Because if you want to make any changes to Schedule 1, any changes to Schedule 7, distribution of powers between center and the states, you need ratification by 1/2 of the states. And if you want to change Article 368 itself, you want to change the very essence of Article 368, you need ratification by 1/2 of the state legislatures. By looking at this process of constitutional amendment, don't you think that if we look at the Constitution, there are some provisions which can be changed quite easily? Some provisions can be changed with some difficulty, special majority. Some provisions can be changed with utmost difficulty, ratification by 1/2 of the states as well. Those are federal features, and federalism is part of the basic structure. This is what experts D. Oliver and C. Fusaro, they write in their book How Constitutions Change. They compare the constitutional bases or constitutional amendments of different countries. And they say that India is very unique in this case. Indian Constitution has provided variety of ways or procedures to make changes to the Constitution. And it has carefully selected some of the matters. Federal matters can be changed with extremely difficult majorities, special majority with ratification by 1/2 of the states. Some provisions can be changed by difficult majority, special majority. Some provisions can be changed for which even Article 368 is not required. You can make changes through simple majority, and we won't even call it amendment. And they use the phrase flexible rigidity for how Indian Constitution can be amended. Although flexible and rigid, these are oxymoron and cannot be used together. But some provisions can be changed with utmost flexibility. Some provisions can be changed with enormous rigidity, difficulty. So that is how the Indian Constitution is a beautiful document. And this topic becomes particularly relevant for not just prelims, but also the mains exam. Look at the question on your screen. An amendment to the Constitution of India can be initiated by an introduction of a bill in Lok Sabha only? No, it can be introduced in either of the two houses. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all the states? No. 1/2 of the states. Which of the statements given above are correct? D, neither 1 nor 2 is the right answer. Look at the mains question. Parliament's power to amend, and this question was asked in 2019. Parliament's power to amend the Constitution is a limited power. and it cannot be enlarged into an absolute power. In the light of the statement, explain whether Parliament under Article 368 can destroy the basic structure by expanding its amending powers. We say British Parliament is sovereign. British Parliament. Why? Because British Parliament can do anything. And in the words of constitutional expert D. Lolme, British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament is sovereign. There is no limitation on the powers of the British Parliament. It can do anything. But the Parliament of India is not sovereign. In our case, sovereignty lies with the people of this country. And Parliament has the limited power in amending the Constitution. You have to be subjected to basic structure. Can you change it to become an absolute power? No. Because in 1976, during emergency, Parliament amended the Constitution by expanding Article 31 capital C. And Parliament said if Parliament wants to give effect to one or more DPSPs, and in this process it violates Article 14, 19 and 31, the law is not unconstitutional only on this ground. Because what the Parliament tried to do, it tried to give primacy to all DPSPs over 3 fundamental rights, which means you are enlarging your amending powers. This matter went to the court, and in Minerva Mills, Supreme Court said this is unconstitutional. Why? Because harmonious relationship between DPSP and fundamental rights is also part of the basic structure. So whenever you try to enlarge your power, the courts will come to the rescue and stop it. Similarly, when anti-defection law was passed, under anti-defection law, the Parliament said, who has the power to disqualify a legislator on the grounds of defection? That power is available with the Speaker. And the decision of the Speaker shall be final and binding. When this matter reached the court, Supreme Court said, we don't have a problem with anti-defection law. In Kesavananda versus Zachilhu 1993 case, Supreme Court said, we don't have a problem, but we have a problem when you say the decision of the Speaker shall be final and binding, because then you are violating any scope, disregarding any scope of judicial review. The decision of the Speaker has to be subject to judicial review, because judicial review is part of the basic structure of the Constitution. Give these examples and your answers will be weighty and full of credibility. Last year in Mains 2025, look at the question. Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. Parliament has the power to amend the Constitution, but there are some procedural hurdles. Bill has to be introduced in either of the 2 houses. Bill should be passed by special majority. If federal provisions are to be changed, you require ratification by not less than half of the states as well. These are procedural hurdles. But then there is a substantive limitation. Even if you follow these procedures, you still cannot change what is called as basic structure. This was the question asked in Mains 2025. So whenever you read a topic which is part of your syllabus, please, for God's sake, take a look at the PYQs as well, both prelims as well as mains, so that you can understand what sort of questions can be asked in the prelims exam from this topic, what sort of questions can be asked in the mains examination, and that's how you can prepare and revise this topic. And if you have understood whatever we discussed today in the class, do let me know in the comment section, and do not forget to press the like button and subscribe to our channel if you haven't yet. Thanks for watching. Goodbye. Take care.